This morning, there is a hearing in Georgia's election interference case against former President Donald Trump and his co-defendants. The judge will consider some defendants' efforts to separate their charges from the larger case. All 19 co-defendants have pleaded not guilty and have waived their right to appear at today's arraignments. So for more analysis, I want to bring in CBS News legal contributor Rebecca Roiphe. Always good to see you, Rebecca. So talk to me about the strategy that some of these defendants are pursuing to separate their charges from the larger case. Why would they do that? How likely is it that the judge will grant this?
So, some of the defendants have asked for what's called a speedy trial, which would mean that their trials would begin in October. Some of the other defendants have asked to have their cases removed to federal court. This creates a really difficult situation for the judge because this is a RICO case, which means that it is a criminal trial against what is alleged to be a criminal organization. And so, traditionally, prosecutors like to try those cases together. But because of this request for severance, the court will have to decide whether to grant the motions to sever the cases and allow some of them to go early and some of them to go late. Those who want to go early, well, that's an interesting strategy. It may deprive them of certain abilities to make certain motions, but it also forces the government's hand, makes them act early, and it also gives the other defendants a preview of their case. So it can be strategically beneficial to those defendants who don't go early, but rather wait to have their cases tried later on.
So there are trial dates sort of already set for Trump's three other criminal cases. Is that something that the judge in this case would then take into consideration while trying to determine the schedule for this case?
Well, each of these cases is different. It's being tried in a different court. In this case, a state court when there are federal trials going on, and another state court case. So it isn't exactly that we have, as you say, a kind of traffic jam of cases, and the court has to consider when it can go forward. But, traditionally, each of these cases is separate, and these decisions are in some ways made separately.
And then I want to ask you about the case in Washington, right? The federal election case with special counsel Jack Smith. He's warned yesterday that some of Trump's statements could taint the jury pool. What are the concerns there?
These are significant concerns. Of course, the former president has a First Amendment right to speak out, and especially when he's a political candidate, and this is considered political speech. That is core protected speech by the First Amendment. But there can be some limitations on one's ability to speak when the government has a significant interest in an ongoing criminal case. So if the former president continues to push that line and really say things that can taint the jury pool, as you say, or make it harder for the government to have, for either party to have a fair trial, then we may see the court stepping in and imposing some limitations, hopefully, minimal ones, but some limitations on what it is that the president can say, the former president can say.
So, Rebecca, when you have sort of this is not the first high profile defendant. I mean, at this point, you would think that everyone in the country, hopefully, if they're watching the news and they're interested in their democracy, has a pretty thorough understanding of what the president is being accused of, what his defense is, because he's been pretty open about that, and what the accusations are. So I would think finding a member of the jury who hasn't been paying attention, somebody to be on the jury who hasn't been paying attention, would be a long shot, and perhaps concerning if you found someone who hasn't been paying attention. So what then does the defense and the prosecution sort of consider when looking for an appropriate member of the jury?
Right. I mean, you're not looking for somebody who's been living in a cave, as you say. You're not looking for somebody who has no knowledge of this case. As you say, that would be concerning. Who is this person who really has not been reading the paper or listening to the news at all? But you're looking for people who can be fair nonetheless. So who haven't already made up their minds, who are willing to listen to the evidence, because what we've heard in public on the news and from the former president himself, from the media, that is not what they are going to hear in court. What they're going to hear in court is very curated. It's evidence. It's a judge has decided relevant evidence and things that are not drawing on people's emotions. And so it's those people who are able to block out the noise and really consider the facts and the law as the judge delivers it to them. So that is not a juror who is unaware, but a juror who is fair.
All right, Rebecca Roiphe, thank you.